Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is an ethics program stemming from our Curious Lawyer series, and is a look at ethics from the bench side of the bench and bar line. We ask, who judges our judges? They, of course, judge us and our clients all the time. But when they err, do they face the same scrutiny we and our clients face when we err? We will look at a variety of issues then from the realm of ethics to do a dive into the ethics questions that surround the judiciary, from the Supreme Court and their famous secrecy and absence of an enforceable ethics code to lower federal and state court judges. We ultimately ask how the ethics rules work when judges get to judge their own. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law. From tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, I can neither confirm nor deny. You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land, in our famed Yellowstone, that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education that is often technical, difficult, or stressful. So sit back and grab a cocktail if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. To start this program, let's just step back really quick. Let me give you an overview of what we're going to look at today. You see here on our next slide, we're going to look at the ethics of federal judges and their dilemmas and how those are judged. We will assess how the process is working in terms of the ethics questions that are raised. So we will look today throughout this program at the federal canons on judicial ethics. We're also going to look at the codes and the ethics rules, and we're going to look at the early 20th century to see where these rules came from and how they've worked in the last 100 years as we walk down this ethics road. We're going to look at a variety of different case law examples on ethics violations being charged against judges within the context of disqualification motions, which is sort of the vehicle we look at to understand if we have ethics problems. We're going to look at the fact that the Supreme Court of the United States has, in essence, self-exempted itself from these federal ethics rules, the judicial code of canons that apply to our lower federal judges. These rules just don't apply in an enforceable manner to the Supreme Court, and they've allowed that position to stand. They haven't self-policed. And so this has created, especially in recent years, legitimacy questions that have been raised within the broader social and political system. We have situations that we will look at that are fascinating, where we have the Supreme Court issuing published opinions, charging lower judges with ethics violations for engaging in certain conduct. But when the same conduct occurs in the Supreme Court, there's not even a recusal question raised. And so we have a situation of big picture. We don't have the same rules applying to the Supreme Court that we demand apply to others. This, of course, raises a fascinating question at a 30,000-foot level. And we could go to the famed saying from Justice Brandeis that sunlight is said to be the best of disinfectants. And that policy principle that has long animated, for example, the importance of transparency in government is a shining light to get to the bottom of things, is something that, ironically, the words come from a former Supreme Court justice, and now is being used to question what amount of sunlight is with the 9 people at the top of our third branch of government today. Ultimately, we will look at issues related to self-policing versus pending federal enactments forcing regulations upon them. We also will explore incredible lower court cases of judicial misbehavior and the punishment, or often lack thereof, that is handed out to them for conduct that would land the rest of us in serious trouble. Ultimately, as we explore all these ethics rules and codes, we are questioning and looking at the viability of the system when judges judge judges. Now let's get to the beginning of these ethics questions, and let's go to the early 20th century, about a century ago, to figure out where the ethics rules come from and what prompted actually the creation of ethics codes that are applicable to judges today. And so we can start with District Judge Landis, who was also the commissioner of baseball Landis. He was a federal judge in Chicago, getting a salary of $7,500 a year back then, and he took the baseball commissioner job that paid $42,000 a year at the same time. He refused to step down from the bench, so he did both jobs at once, and there was a public outcry about this. But there were no ethics or bar rules at the time that could control that behavior. And so the result was that the only mechanism to deal with this was arguably a congressional impeachment effort. In turn, the ABA issued a censure for what that's worth, but that was about it. Now the House held some hearings and there were comments, but there was no actual formal impeachment. You see here a statement from one of the representatives, Benjamin Welty. His statement during this was that what is to prevent baseball owners from going into the Supreme Court now and hiring every member on the bench? I think it affects the very soul of this government. That idea obviously echoes these questions about transparency and ethics and the propriety of our judges being removed. At the same time, the Attorney General said that Judge Landis was within his rights. Now, there was a lot of political pressure over this, and so about 14 months later, he resigned from the bench and stayed on as the commissioner. This event, though, is what led to the very, very first set of judicial ethics codes. And you see there a picture of Judge Landis. Looks like a very stern and serious judge. We will continue with Judge Landis because he also found himself in hot water for some racism that percolated into his decisions and made its way up to the Supreme Court too. This brings us to Chicago in 1918, and this is the case of Berger versus United States. It's reported at 255 U.S. 22 from 1921, and here we see Judge Landis in action with some anti-German hatred. Yes, you heard it right, so let's talk about it. The facts are as follows. It is World War I, and there's an espionage case being brought against German Americans for ostensibly helping the German war effort. And of course, the Germans were our enemies in World War I. And so these defendants end up finding themselves in their criminal case before Judge Landis. I don't know if he was tied up doing his baseball work at this point or not, but he was still a district judge. And so here is what Judge Landis actually said on the record. And these are quotes again that I took from the Berger versus United States opinion from the Supreme Court. This is what Judge Landis said, quote, "One must have a very judicial mind indeed not to be prejudiced against the German Americans because, quote, their hearts are reeking with disloyalty." He went further. Another quote. If anybody has said anything worse about the Germans than I have, I would like to know it so I can use it. End quote. I know you're all scratching your head saying, I can't believe it, you can't make it up. Yes, it's true, they're in the opinion, and the third quote is as follows. You are of the same mind that practically all the German Americans are in this country, and you call yourselves German Americans. Your hearts are reeking with disloyalty. I know a safe blower. He's a friend of mine who is making a good soldier in France. He was a bank robber for 9 years. That was his business in peacetime. And now he is a good soldier. And as between him and this defendant, I prefer the safe blower. End quote. So in any event, you can imagine a judge who feels that way about Germans in a case involving German Americans and espionage, didn't go well. And so this case made its way up to the United States Supreme Court. The Supreme Court ultimately held that the prejudice involved here by the judge was so profound, the judge simply should have recused himself from hearing the case of Berger versus United States. Luckily, none of us have to appear before Judge Landis. But he was simply recused from the case. No financial punishment, no impeachment, no sanctions in terms of case assignments. Instead, in order to recuse, life went on for Judge Landis. And this is an early example of the limits of judicial judging of other judges in terms of actually issuing remedies to alter behavior. Before 1990, there was no uniform federal code of canons. And really, it was a state-by-state set of codes that judges were supposed to adhere to, depending upon whatever the bar of that given state said. In 1908, the ABA adopted the first model code for lawyers. And in 1926, as a result of the Judge Landis situation, the ABA finally proposed model ethics codes for judges, and updated codes were then created in the 1970s. But by the 1980s, it was still really state by state, without formal adoption by the judiciary of any codes. This brings us to 1990, where finally the Federal Judicial Ethics Code is adopted, which we will now look at a bit. And as you can see here, we have Canon 2A. Under IT, a judge should avoid impropriety and in the appearance of impropriety in all activities. I mean, it's captioned as respect for the law, and so this idea is it, and then B is no outside influence. And I won't read the whole thing to you because it's long. You can read it yourself. But the gist of this is that there should be no family, social, political, financial, or other relationships that could possibly create the appearance of impropriety or influence that could affect a decision or a judgment of the court. The court must be fully removed and independent, and that's the whole point. And that's why the canon description of what this is about and what it means. You can see here, and we can read it in the bottom half of this slide, an appearance of impropriety occurs when reasonable minds with knowledge of all the relevant circumstances disclosed by a reasonable inquiry would conclude that the judge's honesty, integrity, and partiality, temperament, or fitness is impaired. In that case, public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. Now, this is a very, very important concept because it requires that we, in order to ensure that there's no possibility of an appearance of impropriety, that we take a wide look at this and we recuse if there's even the chance that one could feel that there's some public confidence risk. Let's go to our next slide where we will see the Federal Ethics and Government Act. And this is the requirement that really triggers a need for judges and other elected officials to file disclosure statements listing financial entanglements, ownership of assets, that type of stuff that could trigger the need to recuse. Now, it turns out there's actually no review process for the accuracy of this. It's just a self-reporting mechanism, but the documents are publicly available and you can go search them online and you can, pull up the judge and see the stocks they own or whatnot to figure out if maybe they have a bias in a case. And that can then trigger the need to file a motion to ask the judge to recuse. And this is what sometimes happens and can be the original predicate for having these recusal motions. And those recusal motions are heard under 28 U.S.C. 455, which is the basis to go trigger a disqualification because of this bias issue that we're just talking about based on the canon. Lower federal judges can be challenged, but the Supreme Court judges cannot, because those canon codes simply don't apply to them, and no one's empowered to review the outcome of, a charge being brought against them. And so the problem is that there is no mechanism that's been created. And so it really boils down to self-reporting, at least by the Supreme Court, without an actual basis in law to have a proper challenge that can be adjudged with an enforceable remedy. Here's 28 U.S.C. 455, which gets at the core of the ethics questions we're talking about today in terms of what happens when there is this ethics issue, and then it triggers the need to disqualify. Under 28 U.S.C. 455, federal law allows parties in lower courts to make a motion to disqualify a judge in certain circumstances. Basically, it works as follows. Any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. He shall also disqualify himself in the following circumstances. 1. Where he has a personal bias or prejudice concerning a party, or personal knowledge of disputed evidentiary facts concerning the proceeding. 2. Where in private practice he served as lawyer in the matter in controversy, or a lawyer with whom he previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it. 3. Where he has served in governmental employment and in such capacity participated as counsel, advisor, or material witness concerning the proceeding, or expressed an opinion concerning the merits of the particular case in controversy. 4. He knows that he, individually or as a fiduciary, or his spouse or minor child residing in his household, has a financial interest in the subject matter in controversy or in a party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. Finally, the spouse of such a pertinent person is a party to the proceeding and is known by the judge to have an interest that could be affected by the outcome. So those are the types of things that are quite broad to trigger the need to step aside. And so the procedural vehicle is the motion to disqualify, and judges must disqualify themselves in the following circumstances: personal bias or prejudice concerning a party, personal knowledge of some of the evidence and the facts in the case, a relationship to the situation, financial interest in the outcome he or his spouse has, or a person within the third-degree relationship to either of them have. Let's start, though, by figuring out what's going on here now at the Supreme Court. They proclaim apparently that they follow voluntarily the same rules that lower federal judges follow, but they also say they're different, so they shouldn't be scrutinized. And how do we know this? Here's an actual quote from the letter they sent to Congress recently, and the link is down there at the bottom if you want to read the whole letter. I think it's well worth reading, but the following is of particular interest to us for this program, and it says, "A recusal consideration uniquely present for justices is the impairment of a full court in the event that one or more members withdraws from a case." In contrast, they say, lower courts can freely substitute one district or circuit judge for another. But the Supreme Court consists of 9 members who always sit together. Thus, justices have a duty to sit that precludes withdrawal from a case as a matter of convenience or simply to avoid controversy. Now let's just stop there. Says who that if one or two of them have a conflict or a bias, it's not a matter of convenience. Actually, it's fairly a question of ethics, and 7 can decide a case just like 9 can. Who's to say we shouldn't have a rule saying if 2 have to step aside, we randomly pick some circuit judges to go sit on the Supreme Court and visit by designation for a case or 2? Who's to say there shouldn't be a law requiring that? But there's no magic that says that if 8 or 7 have to decide a case rather than 9, that somehow we are in transgression of some serious ethics issue that cuts the other way. That's such a stretch they offered. And here's the kicker. The quoted language notes individual justices rather than the court decide recusal issues. I mean, it's jarring almost, right? The court doesn't have to figure out if one of the justices should recuse and the other 8 won't judge the one. So, the one at issue gets to decide himself or herself without any other scrutiny being brought to bear on it. That's odd too if the full court or any subset of the court were to review the recusal decisions of individual justices. It would create an undesirable situation in which the court could affect the outcome of a case by selecting who among its members may participate. Well, that may or may not be a legitimate practical concern in terms of, justices trying to raise ethics issues about other ones, to snipe on them, to sort of remove them, to shift the politics of the court. And that may be a legitimate concern. The answer to that may be, though, to get lower court judges to do it and put it before a committee of them. That's how matters are handled all around the world, actually in other democracies, with justices and judges having to face ethics questions. The fundamental point here that comes out of this letter, though, is that we are so special and so different that we shouldn't have to subject ourselves to these ethics canons that the rest of the judiciary is subjected to, and that gets to the hypocrisy of what's going on. Now in time, there was such an outcry that the Supreme Court in 2024 finally adopted and applied to themselves the very ethics code that already applied to the rest of the judiciary for the last 4 odd decades. But they again did not create a mechanism for other judges off the court to judge the ethics questions put to them at the Supreme Court. So it is sort of a toothless exercise. Basically, here's how it stands. They adopted a code to satiate the public outcry, but they left it toothless. Thus, we remain in the U.S. with the highest level of the courts in this country without an actually enforceable code that can be pressed against them by other jurists or parties with enforcement reality and penalties. Instead, parties can raise ethics issues and hope the justices care enough to say something. Let's now see just how that has worked in the past. So let us do a quick recap of what the lay of the land is for the issue of ethics violations and the question of who judges the judges. For most of our history, there was no actual mechanism short of impeachment. We have federal and state disqualification standards that allow lawyers to make challenges, but the judge on the case, or a neighbor judge perhaps, rules on that. And that requires a party to actually raise their hand and invoke the ire of their judge by challenging them for bias. That is something very hard to do, of course, for the lawyer and client, given the attendant risks of blowback. We have the ethics codes and federal transparency laws, but they do not apply really to the Supreme Court. So what we have in essence is a system of decentralized self-regulation. Congress and states have entrusted the judges themselves with self-regulation, self-policing, and self-punishing misconduct. Now I know my kids would have loved to have been in charge of their discipline for misconduct when they were young. They would have loved to be in charge of punishing their siblings too. But I, for one, am not sure this makes for the most robust ethics system. How do our judges then do when judging themselves? Let's dive deeper into the Supreme Court now and see how they judge themselves and how they judge other judges, all before we move on to some other cases that will probably blow your mind. We're going to start with a look at Justice Sotomayor and the Penguin Random House case. And this also affected Justice Gorsuch a little bit, but not as much as Justice Sotomayor. And here's what we know. Justice Sotomayor has received over $3 million from Penguin Random House. This is in royalties and advances for her book deals. Justice Gorsuch has received over $500,000 from the same entity. Now, a case came trucking along up to the Supreme Court called Nicasio versus Viacom and Penguin Random House. Case number 19, 560 at the Supreme Court. And this case involved copyright questions being brought against Penguin Random House. The question then is, should these two, who have not only received millions from that entity, but that entity also publishes their books and pays future royalties, and so they all have a similar interest in trying to understand whether that entity is violating copyright or not. Are they just too entangled for many reasons? Now they didn't recuse themselves. Now the question we ask is there really any question that if you're sitting district judge and have a copyright infringement case being brought against some publishing company, and that judge got $3 million in cash from the publishing company, is there really any question that would lead to a disqualification motion and the judge would disqualify himself? Not really, but if you don't believe me, let's take a look at a prototypical money case involving judges being motioned to be disqualified where they're getting even a smaller financial interest in a party. That this brings us to the Ninth Circuit United States versus Wolf, reported at 263 Federal Appendix 612 in 2008. This case is one involving the following basic facts. There's an indictment against the defendant being charged in a corporate fraud scheme, and this basically involved inflating of publicly reported revenue figures. And you may remember all back to the early 2000s when all that stuff was going on with Enron and AOL and all these companies. This is an AOL case about the chicanery in accounting. In any event, the defendant was convicted on all 18 counts. But the judge along the way had refused to recuse himself, even though he owned stock in the company that was connected to the scheme. And so the rule, remember, as articulated by the Ninth Circuit, was that Section 455b(4) provides that a judge shall disqualify himself where he knows that he has ownership of a legal or equitable interest, however small. And so here's what the court held based on the unique facts before us. As the court stated, we conclude that the judge did have a financial interest. According to the Securities Exchange Commission, AOL, the company that the judge owned a lot of stock in, or some amount of stock aided and abetted securities fraud by Home Store, and improperly inflated its online advertising revenue based on the Home Store-related transactions by at least $1.5 million and $7 million in another quarter. In this case, the judge's rulings could potentially have had a financial impact on AOL, so the judge could be ruling in a criminal case against a criminal defendant who apparently engaged in inflating revenues which could affect AOL, and the judge owned a legitimate stock in AOL. The court said yes, that creates an appearance of impropriety, and the judge should have recused himself. They slapped him on the wrist for not doing it. That really answers the question about what's going on. Then, when our Supreme Court justices have more than just a little bit of stock in some company they got millions of dollars from, and they have an ongoing expectation of getting money for future book deals and future royalties, and even then could be triggering copyright claims, right? So that's the basic rule now I have here. But this rule is not one that's so firm and rigid that literally, just because a judge may own a share of stock in a company anytime that company somehow comes before the court, the judge has to recuse. So it's not that hard and fast to rule, and you see that from another Ninth Circuit case called U.S. v. Rogers, reported at 119 F. 3rd 1377 from 1997. That's one where there was a defendant who was being sentenced. He had apparently defrauded Bank of America. Somehow the judge happened to own stock in Bank of America. And so this defendant could ultimately be ordered to pay some kind of restitution with his prison sentence back to Bank of America. Now, the defendant had no money whatsoever, and so the court said, look, just because there could be some de minimis restitution paid to Bank of America, and the judge owned some stock in Bank of America, and, could that inflate the judge's holdings by 0.0001 at dose not make sense? So we are not dealing with such rigid rules. But when you're in a reasonable ballpark, like we were in the Wolf case or we are in the Penguin case, then there should be a recusal. But they didn't, and they decided those cases that were pending before the court. And this is what's getting at the hypocrisy of having rules that we expect the rest of the judiciary to abide by, but self-exempting oneself from those rules. It's one thing to have judges judge other judges and protect their own, but to not even be judged, that is a next-level ethics issue. Now let's shift to Justice Barrett and the Americans for Prosperity. This situation involves a 501c3, Americans for Prosperity, and it spent over $1 million to help get Justice Barrett confirmed to the court. Of course, that is its right to engage in that conduct, to do that. But that's a lot of money to be spending on lobbying efforts to sort of get the Senate behind the justice's nomination to put her on the court. But it worked, and she got appointed to the court, and, no sooner had that chapter closed and she's on the court, than a case comes up before the court called Americans for Prosperity Foundation versus Bonta. This is the case number 19251 before the Supreme Court. Here's what actually was at issue in the case, because it's also somewhat important. Not just the fact that the same entity that just spent $1 million to get her put on the court was now before her. Let's even look at the underlying issue that was going on in the case, because it involved speech rights and soliciting contributions and giving identities of donors. And so basically here's the issue. To solicit contributions in California, the state of California had a rule that those charitable organizations had to disclose to the state AG the identities of their major donors. Now, the state said having this information on hand would make it easier to police misconduct by these charities. And Americans for Prosperity said, no, we want to get money from people anonymously and don't want to hand over the names to the Attorney General. That's a fair First Amendment battle, Everyone's got a fair right to fight about who's right or who's wrong on that. But that was the issue. And so it's not just then the issue that there was $1 million spent to help get her on the court. But now we're looking at figuring out whether this very same entity may have to give up the identity of people who donated to that effort to that charity. So this tangled question was one that the court ultimately held that the demand is unconstitutional and that you can't force Americans for Prosperity Foundation to hand it over. But Justice Barrett didn't recuse herself. Instead, she actually participated in the decision of that question. And so the question I guess we raise, given the ethics framing question we're talking about here, is as follows. Is there really any question on a disqualification motion under the law we've looked at that other judges would have to recuse themselves in this kind of situation? We don't need to speculate. Let's look at a real case. We don't even have to look further than the Supreme Court itself. Let's take the case of Caperton versus A.T. Massey Coal Company, reported at 556 U.S. 868 from the year 2009. Here are the facts. There are multi-million-dollar donations to a lower judge's candidacy. The judge got onto the court, the judge then had a case pending, and the entity who donated was a party to the case. The other side said, hey, look, millions of dollars were spent getting this judge elected and put on the bench by you, so the judge has got to recuse. The judge said, I'm not going to recuse. The case went up to the U.S. Supreme Court. And so let's walk through what the U.S. Supreme Court has said about the propriety of this judge's behavior. This is a quote from the Supreme Court. The court has identified additional instances which as an objective matter require recusal. These are circumstances in which experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. End quote. We're not just talking that is about Section 455. And did you violate a statute? Instead, the Supreme Court was looking to say, is this even of a constitutional dimension in terms of the importance of the ethics questions and the need to recuse? The court went on, quote, the difficulties of inquiring into actual bias and the fact that the inquiry is often a private one simply underscores the need for an objective rule, end quote. Recall, that's what we talked about earlier, but let's keep going. Quote, otherwise, there may be no adequate protection against a judge who simply misreads or misapprehends the real motives at work in deciding the case. The judge's own inquiry into actual bias, then, is not one that the law can easily superintend or review, though actual bias, if disclosed, no doubt would be grounds for appropriate relief. End quote. So here's what they said, whether the person who donated the millions of dollars, whether those campaign contributions were a necessary and sufficient cause of state, Judge Benjamin's victory is not the inquiry. Similarly, we don't know if the $1 million Americans for Prosperity spent was the but for cause of Justice Barrett. You know, getting the votes, but that doesn't matter either, the Supreme Court said, when it was looking at this Caperton case. They went on, much like determining whether a judge is actually biased, proving what ultimately drives the electorate to choose a particular candidate's a difficult endeavor not likely to lend itself to a certain conclusion. This is particularly true, whereas here there is no procedure for judicial fact-finding, and the sole trier of fact is the one accused of bias. So what did the Supreme Court hold? It held the Constitution required recusal. The ethics situations were of such dimension here that the Constitution and due process mandated this judge be recused. And so this case went all the way up to the Supreme Court, which issued this ruling saying that the Constitution found the bias risk to be so great that the judge had to recuse himself. And the Constitution said this in part because there needs to be an objective, fair look at this. In large part because there isn't even a proper mechanism for an individual judge to do it, him or herself. Yet when they shine that ethics spotlight on others, they can expound fantastic rules, such as the Justice Brandeis sunlight transparency idea, and they can speak from up high on the mount about the importance of ethics as they condemn this other judge justly. But when the light is shined on them, suddenly very different set of rules apply, as we saw with Justice Barrett, who didn't recuse herself and didn't face an inquiry from other members of the court. You see here on this next slide that we're looking at the proposed Supreme Court Ethics Recusal and Transparency Act of 2023. And the politics to this, of course, is complicated, because all politics are complicated. But here's the gist of it. And this comes from just some statements from some hearings. This is from Senator Whitehouse in particular, and I'm not, to be very, very clear. There are political statements from senators on each side of this question, so we're not picking one over the other. But this is just to bring to bear for us on the ethics questions that particularly matter. So we've picked those statements that come through prisms that frame this in terms of the ethics inquiries that matter to us. And so here's the statement. There are good reasons Americans are losing confidence in their Supreme Court. Special interests are spending millions to try to rig the judiciary in their favor, and the justices continue to shrug off their own self-imposed ethics crises. Every other major decision maker in the federal government is subject to these kinds of ethical guardrails. It's clearer than ever that it's time to bring a fair and transparent set of rules and procedures to enforce the rules to the highest court. This is really important, this statement, and the reason I put it here for you is because it talks about a double problem. One is that there must be rules that actually apply. We must know that code of judicial canons that apply to all the federal judges in the country. Except 9, right? We need rules that apply to them. Is it going to be that set of rules? Why not? Or is it going to be another set of rules? Maybe. But what are those rules? We need a substantive set of rules that actually apply to them. And what's particularly critical here is we need procedural mechanisms that exist so that those rules can be enforced. We need to have some sort of process by law which exists for everyone else in this country to figure out how these rules are going to be enforced. Will it be motions to disqualify that are brought before the Supreme Court and decided by the rest of the justices? If that's not a good rule for the reason Justice Roberts echoed in that letter that he sent because we don't want the Supreme Court justices sniping on each other to sort of create or shift outcomes, then what's another procedure? Do we perhaps ask that all the chief judges of the circuit courts get together and they form an advisory or a conclusory board of judges that will hear the motion and enforce it? Or do we use a random selection of judges from some other set of judges? What is it? We need a procedure so that we know this isn't just left in the hands of someone saying to the court, oh my gosh, you should recuse yourself, and the lone justice saying, nah, I don't think I'll do it. And the inquiry begins and ends there. Now, the proposed law is to actually have a conduct and a process for enforcement. And so what the Congress is currently saying is that you, the Supreme Court, you better get with this issue of ethics and adopt a code of conduct. And as we saw earlier, the result was they adopted the same code that applies to other judges, but did not create a mechanism to allow real enforcement. So these laws are still pending as of 2024, given the crisis that has erupted and engulfed the court on this issue of ethics and judges judging judges. We looked briefly at Canon 2, which is really our principal one that tends to animate most of the conversations, but let's start with Canon 1. Quote, an independent and honorable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary may be preserved. End quote. This is the ethics framing principle that then governs the interpretation and application of other ethics canons. Now, Canon number 2, 2A, here are quotes from Canon 2A actually that we looked at already, but these are the ones to keep in mind. The judge must act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary, and must avoid impropriety and the appearance of impropriety in all activities. And avoiding even the appearance of impropriety is critical, as it is not just did you do something wrong or not. You may have done nothing wrong, but it could still be seen as improper. And so that means even if there is no wrongdoing, a judge should be cautious and step aside in certain cases to preserve public confidence. As we move to the next slide, let's take a look here at Canon 3. This involves the idea that the duties of the judicial office take precedence over all other activities. The judge must perform those duties with respect for others and should not engage in behavior that's harassing, abusive, prejudicial, or biased. So, for example, a judge should be faithful to and maintain professional competence in the law. He or she should not be swayed by partisan interests, public clamor, fear of criticism, and the like. A judge should hear and decide matters assigned and should maintain order and decorum in all proceedings before the judge. We will be exploring how this works shortly when we see a judge handcuff a kid in the court, not even a party in a case, and then see how the other judges judged that judge. Now let's go to Canon 4. And Canon 4 on our slide, you can see here, talks about how a judge may engage in extrajudicial activities, civic, charitable, education, religious, social, or financial type activities, of course. And of course, a judge can speak and lecture on the law and even non-law related subjects. But what's the fencing principle? Here it is that a judge shouldn't participate in these activities if it detracts from the dignity of the judge's office, interferes with the judge's official duties, or if it reflects adversely on the judge's impartiality. So that line can be hazy at times, and the fundamental point I think that we can distill from this canon, and several of them as they tie together like DNA helix strands, is that a judge shouldn't engage in conduct that gives the impression that the judge may lack partiality on certain issues or may favor certain people. Now let's move to the judge who handcuffed the defendant's teenage daughter in court. Yes, you heard that right. This brings us to the West Coast, and we're going to go to sunny San Diego in 2023. And here we have a case where a federal district judge, Judge Benitez, held a hearing. And this is a criminal case, and the criminal defendant was in court. And the hearing being held in this criminal case was on whether the criminal defendant's bail needed to be revoked. Basically, the defendant had served his sentence, was then released from custody, but had supervised release, like probation terms and all that. And the defendant apparently violated his supervised release and probation terms and was potentially facing another jail term for this violation of the supervised release conditions. And so there's a hearing being held to address this, and the defendant was at the hearing, obviously. And the defendant's daughter, this 13-year-old girl, was in court also. So the defendant actually told the judge and expressed some concern that his daughter was hanging out with people who might, quote, lead her down into the same path I went down in, end quote. Now, why exactly the defendant was saying that is unclear. Perhaps the defendant was saying that I'm worried my daughter's hanging out with bad people, I don't want to go to jail, I got to be here to look after her. But for whatever reason, he says, I'm worried about my daughter. The judge then turns to the marshal and says, you got handcuffs. The marshal, at the judge's direction then, believe it or not, actually cuffed this 13-year-old girl in the jury box. Now, the girl, as you can imagine, is 13 years old in a federal court watching her dad, who's been in jail, getting ready, maybe to go back to jail. And all of a sudden, she finds herself cuffed and put in the jury box. She starts crying, no surprise, and probably suffered significant trauma. And basically what happened is she was cuffed in there. The judge spoke to her for a while, and after allowing her to be released, the judge tells her that you're an awfully cute young lady, but that if you don't avoid drugs, you'd end up in cuffs and be right back there where I put you a minute ago, end quote. Wow, pretty serious and obviously serious. If the rest of us handcuffed someone without their consent, we'd find ourselves in a heap of trouble. And that led to the Ninth Circuit opening a judicial misconduct case number 23937. This was in February 2023. So what did the Ninth Circuit do? A panel of several Ninth Circuit judges got to judge Judge Benitez. So let's break down what they did exactly. They interviewed the witnesses to this and sent questions to Judge Benitez to answer. And after this fact-finding mission, they wrote a very lengthy, detailed 26-page order. Judge Benitez told the judges that no one complained or objected, so he should not be found to have engaged in misconduct. But this panel of Ninth Circuit judges, they condemned Judge Benitez. They found his conduct violated canons 1, 2, and 3 that we have looked at here. But they went further. They found that his handcuffing violated the young girl's Fourth Amendment rights. Remember, I am sure you have watched our Curious Lawyer Bill of Rights series where we spend 1 hour on each of the first 10 amendments. But if not, go check them out. And the Fourth Amendment program addresses the seizure rules. The Ninth Circuit said here, quote, In directing the deputy marshal to handcuff Mr. Puente's daughter and requiring her to stand in the jury box, Judge Benknitus ordered her to be seized within the meaning of the Fourth Amendment. End quote. They cited law for that, of course. Indeed, in criminal proceedings, due process does not permit the, quote, routine use of visible shackles, absent an individualized determination that it is necessary to maintain safety. End quote. That is Supreme Court law also for actual defendants, let alone members of the public sitting in the court. They also noted that no law was given by Judge Benknitus to justify his actions, and they could find no law either to justify the actions. And remember, Judge Benknitus made his defense that no one objected. Here is what the Ninth Circuit said. Quote, at no point during this investigative process has Judge Benknitus accepted that his actions were ill-advised, improper, and damaging to the public's trust in the judiciary. Judge Benknitus has in fact placed blame on others, particularly the federal defenders, for his actions that day. Judge Benknitus has, at every point, maintained that he acted only with the best intentions toward Mr. Puente's daughter and her father. But his good intentions do not excuse his conduct during the Puente hearing, which displayed misguided and inappropriate methods that exceeded the authority vested in him. His actions not only harmed Mr. Puente's daughter, but also impaired the public's trust in the institution. End quote. They then found that Judge Benknitus's actions towards Mr. Puente's daughter constituted abusive or harassing behavior. And given the canons, they found his actions constituted conduct prejudicial to the effective and expeditious administration of the business of the courts. So, this lengthy opinion waxes at length about the law, ethics, and his conduct. But let's get to the part of the opinion where they actually address punishment. And here's where the opinion gets single-spaced and candidly thin. The punishment they issue? Public reprimand. A public reprimand which the order was, and no more criminal cases, but that is a bit of a red herring as he was senior and had already recused from such cases. So he hears civil cases and moves on. So this document saying you were a bad guy, that is the punishment. No loss in salary, benefits, or anything like that. It's a good example of judges judging judges, and in my opinion, closing rank without holding their own to the same standards they would impose on the rest of us. It's one of the problems we confront from an ethics perspective with rules that wax loudly about ethics but which carry little remedial power when it is judges judging judges. The title of the slide here is an understatement, it turns out. We have an actual Seventh Circuit case of a judge on trial in federal court being judged by a federal judge in that case. And then we have the federal judge presiding over the trial himself, creating an ethics dilemma and needing to be judged by the Seventh Circuit judges. Let's take a look now at the case of the judge who goes on vacation with a prosecutor at the end of the trial. You remember from the beginning, our ethics canons about avoiding even the appearance of impropriety and not having enmeshed personal relationships that could question whether you are able to remain impartial. Those canons are play in this case, and this is the case of United States versus Murphy. It's reported at 768 F 2D 1518. It's also coming out of the Seventh Circuit in 1985. For those of you in the Seventh Circuit, I'm not picking on you as we have these cases all over the country. It just so happens it's a useful case to look at. So basically what we have is the case of the judge who went to jail for bribery. And now we have the judge in the case of the judge who went to jail for bribery. The judge himself facing his own ethics questions. And so it's sort of, I had to use this case because you just can't make it up right. The defendant judge is going to jail. And the judge overseeing the case of the defendant judge himself trips into an ethical dilemma. And so here's the ethical dilemma. We have Judge Murphy going to jail in the case and Judge Corus being the federal district judge presiding over the case. And it turns out that Judge Corus was a close friend of the prosecutor, the federal prosecutor who was trying to put Judge Murphy in jail. And indeed, apparently they were the best of friends. I mean, these were good friends, the prosecutor and the judge. So Judge Murphy's RICO and bribery case goes through the process. And he then gets sentenced by Judge Corus. And what happens is immediately after our convicted judge defendant is sentenced, Judge Corus goes on vacation with the prosecutor, like literally the next day. Apparently, basically, the sentencing hearing was actually advanced to be done. So that this group vacation with Judge Korus and his wife and kids and the prosecutor, his wife and kids, are all going to go off on a little vacation. They had their vacation planned, but the sentencing of Judge Murphy was in the way. So they decided we got to advance the sentencing. Let's get him sent off to jail so we can go on vacation. And they did all that. So in any event, this makes its way up to the Seventh Circuit, and the Seventh Circuit found that this level of friendship was unusual. And the objective test under 28 U.S.C. section 455, that question we raised about the appearance of impartiality, did indeed require disqualification. Namely, that Judge Kakor should have disqualified himself. And basically, the governing rule of law. And coming out of the case is that quoted here from page 1538. Quote, "Most people would be greatly surprised to learn that the judge and the prosecutor in a trial of political corruption had secret plans to take a joint vacation immediately after the trial." An objective observer might wonder whether the judge could decide the case with the requisite aloofness and disinterest. End quote. You just can't make it up. I mean, this is sort of, we have judges gone wild when presiding over cases of other judges gone wild. I mean, it's just sort of everyone's off the playing field here. But what ultimately happened here, though oddly enough, is that Judge Korus actually avoided disqualification. How could that be, you ask? Ultimately, because the defense knew about what was going on and waited too long to file their motion. And as it turned out, apparently the defense lawyer was also hanging out with the judge at social events, and they were all a gaggle of friends. So it was deeply improper, as the court held. But it also did not matter. I am not sure that is sending the right ethics message, Hen. The appearance of even impropriety is the litmus test, and that was more than met here. There you have it then. Judges judging judges with even a free pass again. At most, there is this public opinion, which is sort of a slap on the wrist and public reprobation, but nothing more for what was a real ethics violation. Now let's double-click a bit on the remedies that flow for judicial impropriety when judges judge other judges. We can start with the first case from Utah called in Ray Judge Dow, and this case number is 193 JC012. This comes out of Utah from September 13th, 2019. And what I've actually done for you here is I have linked in your materials the actual decisions, so you can go read them, so that you don't just take my word for it. So let's look at what happened with Judge Dow. This case in Utah involved a judge who texted a photo of a man's scrotum to his court clerks. Yes, that is correct. That's what he did. The remedy, he was reprimanded. I think the rest of us may go to jail, or we'd probably be disbarred or put on a sex offender list. This judge got reprimanded. That was Utah 2019. Now let's go to Texas in 2019. This is the case of In Re Judge Robinson, case number 18-0510. It's a February 20th, 2019 decision. Here our Judge Robinson entered the jury deliberations room while the jury was deliberating a verdict. And what the judge told the jury was that God had come to the judge and told him that this man should not be convicted. Now this case ended with the ethics conclusion of a public warning. The judge fell on the sword and apparently immediately recognized that he should not have told the jury that he had been told by God that the man should not be convicted, and he shouldn't have shared those conversations he had with God with the jury. And so he accepted responsibility immediately, and it resulted in a public warning about the judge. A public warning you don't say. The next case is in Ray Judges Adams, Jacobs, and Bell, and this comes from the Indiana Supreme Court in 2019. And yes, the title involves 3 judges. This one is so unreal that you'd swear I made it up. But no, it is real. Here we have 3 judges who were hanging out having a good time drinking in public at bars. They were all on a trip to attend the Judicial College the next day. At 3 a.m., they apparently tried to go to a strip club, but it was closed. Let's pause there. These judges were in town to go to the Judges College for training, presumably at 8 a.m., and were looking for a strip club at 3 a.m. Wow, judges want to have fun too, it seems. But alas, it was closed, so I guess they were hungry, and they went down to White Castle to grab some White Castle burgers. Now they end up getting into a verbal and a physical fight with one person named Kaiser. This Kaiser was someone who just showed up there yelling out of the car, and one of the judges gave him the bird. So Kaiser pulls in the parking lot. And so the 3 judges and Kaiser end up getting into this verbal and then physical fight. One of the judges actually kicks Kaiser in the back. Kaiser, believe it or not, pulled out a gun and shot 2 of the judges. They were seriously injured and taken to the hospital for multiple surgeries. Their blood alcohol levels were 0.21 and 0.17. This led to judicial misconduct findings when the judges were hauled before the state and the Indiana Supreme Court, and they were found to have engaged in misconduct. Let's pause. They got in a 3-on-1 fight with someone when grossly intoxicated. They kicked him on the ground, and that led to a shooting where 2 of them were shot. Misconduct? Clearly. How did the Supreme Court judges judge them? They received suspensions ranging from 30 to 60 days. That is it. And now our last little case here, looking at remedies. We've kind of worked our way up from reprimands and public warnings to suspensions, and now getting into some more serious remedies on this one. This is the case of In re Judge Thompson. It's reported at 194 P. 3rd 1281. It's coming from Oklahoma in 2008. Here we have a judge who used a sex gadget penis pump while on the bench in trial, apparently, and exposed himself to others while using this sexual gadget. This judge in turn was disbarred, and it also led to a criminal conviction for the use of the sex gadget and the act of exposing oneself to others. So here we have a powerful remedy. And there you have the links to go read the decision so you can see it's all real. So this brings us to our conclusions. We have looked today in this ethics program at the various ethics rules that are supposed to control judicial impropriety. These rules exist to instill confidence in the public, in us as lawyers too, that the judges we appear before are held to the same standards the rest of us are held to. We looked at the ethics canons, model rules, and actual federal law on disqualification, which is where ethics principles are housed in the federal code. We looked today at judges judging judges. And so let's recap what we saw starting from the United States Supreme Court on down. We saw where these judicial ethics dilemmas really started with Judge Landis testing the boundaries back in the early 20th century, along with his racist rants at Germans, which led him to the Supreme Court in turn. And we saw him be ordered off a case, but not punished in any manner for conduct the rest of us would be punished for. It was an early sign of the problems of judges judging their own. For the Supreme Court, we saw that until 2024, they did not even have a code of ethics that even ostensibly applied to them, even though they all claimed to follow the Judicial Ethics Code. They finally self-adopted the code, but DeHay intentionally refused to make it enforceable by way of other judges judging them, which makes it look more like a PR move than an actual attempt at real ethics reform. So we looked at some cases from both sides of the political aisle. We saw basic fact patterns where the 9 don't face any consequences for matters other judges would at least face some consequences for. The first point, then, that we see that is so important. It's bad enough to have judges judging judges, but to have a judge judge himself or herself hardly works. And we saw then cases of state and federal judges in the craziest and strangest situations of improper behavior, confronting judicial ethics panels of fellow judges, and receiving what are basically light sentences that amount to written admonitions mostly. A judge handcuffs a 13-year-old who is in the court, a violation of her Fourth Amendment rights, and an assault and battery by any basic definition. And the result? Fellow judges admonished in an obscure document the behavior. We also saw state court examples of some really serious misconduct that led to reprimands and 30-day suspensions. All in all, I think we have seen a mosaic that makes a picture that raises questions about the viability of judges judging their fellow judges. Let's be clear on the narrow cases. A judge who handcuffs a teenager formed the public section. A judge who goes on vacation with the prosecutor at the end of a trial. 3 judges get in a drunken brawl with someone. A judge says all Germans are terrible people. Other judges sending sexual pictures and exposing themselves. This leads us to the last question you are left with. Is our system working well from an ethics perspective when judges from the same basic court are judging fellow judges? Should we have a system that externalizes the judging of judges to judges from other states or jurisdictions? That is, should federal Judge Benitez from San Diego have been judged by the Ninth Circuit who know him and hang out with him at events? Or would it have been better to ask a panel of state judges from, say, Nebraska to judge the conduct? And ultimately, should there be real teeth to punishments? Or perhaps even a bar group of esteemed lawyers should do the judging. Who judges our judges and does it work? That is the lasting ethics question. we leave you with today. Thanks for watching. Check out our full range of Curious Lawyer programs. And as always, if you have questions, please reach out.